Your Honor, that was a mistake from
How much time did you give the court to prepare for today's hearing?
no time, Your Honor.
Counsel for Real Water, how much time did you give the court to prepare for today's hearing?
Not enough, it appears no time, Your Honor.
Well, it's 1:01. You all reached in writing and stated that you all wanted to come in at 1 o'clock so that you could get started earlier. The court offered that extra time. I don't have everybody here, so we're gonna see who wants to make appearances, and we're gonna find out why we don't have everybody here. Okay, we understood Mr. Parker would be a little bit late, but we were not told anybody else. So we have a no-show by counsels for plaintiff. Counsel for Real Water would like to make your appearances.
Good morning, or good afternoon, Your Honor. Joul, Odou, Mark Love, and Eric Freeman on behalf of AffinityLifestyles.com Inc. and Real Water.
Thank you. On behalf
Good morning,
of,
Your Honor.
go ahead, do you all want to make your own individual, if you want to be heard, you can feel free to stand up and say it. If not, if you're good, you're good.
I just wanted to say, Mark Love for Real Water as well, Your Honor. Good afternoon.
Good afternoon. Okay, ET&T Terrible Herbst.
Good afternoon, Your Honor. Valerie Rojas and Young County 6 for Terrible Herbst.
Okay, and we understand we have one person observing, and then Mr. Kaufman. Okay, let's, counsel, you're late. Would you like to make your appearance? We were doing a no-show for plaintiffs' counsels.
Yes, Your Honor, I apologize. Eric Pepperman for plaintiffs, and Mr. Kemp is right behind me.
Okay, well, counsels, first thing the court's gonna ask you is, what time and date did you all provide the court, if you assert that you did provide the court, any revised depot designations? And where was it provided? Date and time? And when and where?
Yesterday
What time?
at 4:30, 4:45 is my best guess. We delivered I believe we delivered a courtesy copy to the outbox, and
It's interesting you say the outbox, because you're actually, you know where we found it? Today, about an hour or so ago? Way back in the back of the outbox, for outgoing things for runners. Right? Not in the inbox, for a court to look at. Not even at the front of the outbox, but pushed way back. So you can appreciate how much time did you give the court to prepare for today's hearing?
Your Honor, that was a mistake from
How much time did you give the court to prepare for today's hearing?
no time, Your Honor.
Counsel for Real Water, how much time did you give the court to prepare for today's hearing?
Not enough, it appears no time, Your Honor.
Counsel for ET&T Terrible Herbst.
I would agree, no time.
Okay, did either Terrible Herbst or ET&T, Terrible Herbst, ET&T, or Real Water confirm and check to ensure that the court had everything sufficiently on time for the court to review it? Real Water, did you?
Your Honor, we had mistakenly believed that the court had everything and apologize that the
As
court
of
does
when?
not.
What efforts did you do to ensure your individual obligations with regards to courtesy copies 5 days before a hearing under the EDCR, at least more than 24 hours? Counsel, what efforts did you all make?
Your Honor, if you're speaking of the depot designations or
Yes.
the depot designations, there was a hand served. There was a letter that was electronically served that representative was hand served that we received at 5:01 p.m. yesterday.
After close of business hours, right?
Yes, Your Honor, it is.
So what efforts did Real Water do to ensure that the court received anything timely for today's hearing as an independent requirement of each of the parties? I'm going to ask you each.
Your Honor, we had believed that it was being submitted. It did not make it here timely.
So what efforts did Real Water do? Like, when were you done with whatever your discussions were? When were you ready? When was whatever was provided to plaintiffs? Or did you all have, did you do your own separate disc or
No, Your
jump
Honor.
drive?
No, Your Honor, Joul, on behalf of Real Water, we had an extensive meet and confer.
When?
I will have to look at the calendar. I don't have that date in front of me, it was within the last few days. We had an extensive meet and confer. I believe it was, I'll have to look at my calendar, Your Honor. I didn't have that prepared in front of me, but I can tell you in a moment.
Counsel for ET&T, DBA Terrible Herbst, what efforts did you make to ensure the court received anything timely?
Your Honor, we did not confirm that the court received it timely. We provided our designations on Friday to plaintiff's counsel, and like Real Water, received the electronic notice last night after hours.
After close of business yesterday, right?
Correct.
Does anyone know even when the runner actually got into the courthouse? If there was a runner? Did anyone confirm?
I believe it was,
Did anyone confirm when it was actually delivered?
I saw the runner leave our office. I talked to the runner before he left our office yesterday. My best estimate was 4:15 at the latest.
Wait, 4:15 the latest? Take a look at the drive and see what time he actually, things were downloaded onto the drive.
Again, Your Honor, I
The
wasn't.
letter itself on the drive says it wasn't even submitted into the drive until after 4:25 PM. That's why, counsel, I'm trying to give you the benefit of the doubt.
I'm not gonna disagree with the timing on the drive. I know,
Any of you all can come forward, I can show you what time the drive shows. Despite the letter somehow saying it was December 22nd, or the second part of the letter saying that you got things to the court on December 27th. But the drive itself says the letter was not even put onto the drive until after 4:25 PM.
I think the letter was just, we wrote over it from the last one that we submitted, and we must have made a mistake and not revised the date on the 27th, but.
But you got disclosure, you got everyone's disclosures and everything on the 29th and decided not to give anything to the court until after close of business yesterday for today's hearing?
We received
You
terrible.
heard Terrible Herbst say Friday, that's why I'm
Yes.
using Friday.
They provided revised objections, which were just withdrawing objections from the prior set that was submitted. We updated all the, we went through and looked at withdrawing certain designations in witnesses over the weekend. We also updated the transcripts to reflect the fewer number of objections, and put that together yesterday when our staff was back from the holiday, and took longer than expected. We weren't able to get it until the court, till the afternoon.
Not, counsel, don't say afternoon, it was after 5 o'clock, please. Afternoon, it starts at 12:01. After close of business, after the court was closed.
Yes, Your Honor, I'm not gonna disagree with that. I do apologize for the timing.
Or this morning, we know it wasn't there as of late yesterday afternoon. And is there any reason why? I mean, you even stated it was put in the outbox. Why was it put in the outbox,
Well,
folks? Way in the back of the outbox.
I misspoke. I meant the box outside the courtroom. I did not know it was put in the outbox.
Ironically, you actually were correct. It was
I know.
pushed in the way back of the outbox.
Yes,
No
that
one could
was a
see it. The only
mistake.
reason why we saw it is because we have another case, as you know, we have a 2-day evidentiary hearing that were coming in, and so we were looking for things for them, and I have a wonderful court recorder looking through everybody's boxes, because we scrambled high and low looking for everything, couldn't find anything, and so we looked everywhere, and all of a sudden it was there. Wasn't there yesterday afternoon, after 4 o'clock. So, counsel for plaintiffs, did you independently look at what you actually submitted to the court to ensure that it was complete and actually had the designations on it on the objection pages? You personally, or Mr. Kemp? Did you actually look at what was submitted to the court, counsel? Yes or no?
I mean, I looked at versions. I didn't put.
Before it was actually submitted to the court, did you bother to confirm that it was complete and accurate?
I did not look at it at the final thumb drive to see what was on there before it was submitted.
Counsel for Real Water, did you bother to look to see that something submitted to the court was complete and accurate? You understand this is all Rule 11 stuff, right, folks?
Your Honor,
Non-sanctionable stuff. So Counsel for Real Water, did you bother to look at anything before it was actually submitted to the court, the final version?
Your Honor, Joel, on behalf of Real Water, we did not receive the jump drive and did not look at the contents of the jump drive.
Counsel?
We received only the cover letter.
So you don't even know what the courthouse?
We took plaintiff at their word as to what they were providing the court from the cover letter and from our meet and confer last week and our meet and confer again yesterday.
So do you have all the files that you could look at to see supposedly what the court has a mirror image of?
Based on the court's question, I'm concerned that we may not, but we have the files that we use in our meet and confer. So if they're the same, then I do.
Did anyone bother to see what the final versions were for the court supposedly to be prepared and reviewing for this? It looks like I got 0 for 2. Counselor ET&T Terrible Herbst. Did you?
I do have the revised charts. It does look like they were revised to strike out, for example, on Bush, the withdrawals that we requested.
My question was a little bit different, as you know.
Microphone from behind you.
Counsel, I asked you whether or not you bothered to look to see what was actually submitted to the court to ensure it was full and accurate, since it was submitted on behalf of all parties to this case.
No, did not look at the jump drive, Your Honor.
Do you have any idea what was actually submitted to the court?
Presumably the same charts that I've received, and presumably the color-coded version of the cutouts of the deposition transcripts.
Are you saying the chart you received actually has line and page designations? Take, for instance, Lois Kessler? The objections on the top part?
No, Your Honor, all the page and line objections were removed from that deposition. It's only.
Not all. Only part. That's why, once again, I don't have my secret double decoder, folks.
The two objections, I think Your Honor is referring to, the two top general objections, were just to the entirety of plain Ms. Kessler.
And how would the court know that?
I'm just looking at the descriptions as the basis for the objections.
And how would the court know that in certain sections, it's everything, in certain sections, it's subparts, particularly when the court raised that very issue when you all were here on the 27th to not do it to me, because you remember what happened when you were starting on, oh, we're only doing a hearsay objection to this subpart, even though it's designated everything with everything. So, counsels, here's what we're gonna need to do with depot designations. In light of the parties, local noncompliance, because no one even bothered to look at what was submitted to the court, no one even submitted anything to the court, even at judicial day, even late on the day before. It was after close of business or sometime this morning. But you all knew I was in hearings all morning because you knew you weren't going to start till 2 initially, because I was supposed to be in an evidentiary hearing that just got changed last minute yesterday, but that's not your issue. But so you knew the court was not even going to be available, but you chose not to provide it to the court. So here's what you're going to do. You're going to have a reader question, answer, and raise each and every one of your objections during the trial, just as if the person was here live, just the way that you do it in normal ways, because it is not appropriate for, I don't even know what you all have. You all don't even know what this court has. Nobody's bothered to check. No one's given a cross-reference. Nobody's done anything for this court to have any understanding as to what would be the court. Plus, you go to the first two, and some have page and lines like they're required to, right? That's straight out of the rules, and straight out of the court's rules as well, right there. And others don't. Well, I gave you all a chance to give me the secret decoder ring. You chose not to, and you chose not to even give me anything that gives me an explanation of what actually is going to be an issue. If you say, defendants object to testimony of this witness being violation of NRS 50, what testimony are we talking about? That's as simple as going to Kessler, and yes, it's other ones too. I was opening up these to try and see if maybe it was inadvertently just one and I could address the others, but it's replete throughout. So what you're going to need to do is the standard way that you would do deposition in lieu of live testimony. You're going to have a reader come to the stand. You're going to do a question. The reader's going to read if you have an objection, you're going to need to stand up in front of the jury, raise your objections in front of the jury. The court will make a ruling, question by question by question for each and every one of these. Other than what, since we were partly through Bush, if you ask me for Bush, to try and finish Bush, do that, but it's not fair or appropriate, nor have you given me any tools that this court can in any way make a ruling, nor do you even know what you're going to be arguing in front of the court, because no one seems to even know exactly what the court has versus what you have. So that's the way you're gonna have to do the process. I'll ask you with regards to Bush, whether you want me to finish Bush, because I said I would finish Bush on the 27th, and you all chose not to wanna finish Bush on the 27th. So I will finish Bush if you want today, if it's doable. But all the rest, question and answer, and that's the standard process, so no one is adversely impacted in any manner whatsoever, because it gives the full opportunity to do what you would do in any normal trial. So we'll have a reader, the reader will read as if they were the person, question and answer, and every single objection that you wish to raise can be raised in front of the jury for the court to do its ruling in front of the jury. With respect to people claiming that there is assertions on motions eliminated, the violations thereof, you all know what you can and cannot do. Don't try and do things in front of the jury which violates a motion eliminated. It has its impact. You all can easily do a meet and confer with regards to any ones that you think violate a motion eliminated. So that should really not come up, because you've got the benefit of having all the designations to work that out, so it's really a non-issue. If, however, someone chooses to do it in front of the jury, we'll have to address it at that time during the course of trial. So that is what we're doing for depot designations. With regards to Bush, as I stated, I finished Bush because we started Bush. Do you all wish the court to finish Bush, or do you wish to do that in the same process as everybody else, question and answer on the stand and objections raised in front of the jury?
Your Honor, on behalf of Chair Herbst, we would prefer to just do it as we're doing with the rest of the depositions. Do it on the stand.
Okay, it's gonna be majority rules here. That's the fair way to do it, since I had offered it before on the 27th, despite the challenges that were there, which have even been made worse for today.
Plaintiffs would prefer to finish Mr. Bush. I think based on the revisions, there's only 2 objections left to address.
Counsel, wait, there's only, counsel, you say 2? Do you realize how many are on this page chart for the court? There is 1, 2, 3, 4, 5, 6, 7, 8, there's about 20.
I have the same chart, Your Honor, which is why I suggest and those are terrible herbs, the majority are designations, so we'll withdraw those.
Well, I'm not asking anybody to withdraw. You have to be, let's be clear, the court's not asking anyone to withdraw your designations, withdraw your objections. It's just gonna be a form. It's gonna be the procedure. The procedure is gonna be, this court was more than willing to do it as a time and cost-effective method to try and resolve depot designations prior to trial. You all have precluded the court from being able to do so by your actions, by you all choosing not to even see what you gave the court, and not even giving the court anything till after close of business yesterday for purposes of today. Those were all you all's choices. The sanction component, I'm deferring till the time of trial. But for today's purposes, we're just addressing the impact of how you were precluded the ability to do pre-trial depot designations. I haven't heard from Real Water. I've got 1 and 1. You're the tiebreaker. Real Water, which way do you want Bush?
Your Honor, we would naturally prefer the video depositions, but if it's, we're going to have just one video deposition, it doesn't seem to make sense, so we should do them all the same. So we should do the read if that's what we're gonna do.
Do you all have a method by which you could do a cut for a video deposition, a question, a pause to see if there's an objection, and then an answer?
I was gonna suggest that, Your Honor. I think we can do that with shame.
Like I said, this court wants to I'm not in any way changing anybody's testimony or designations. I'm giving you the same opportunity that you had if somebody was live, or if you have that somebody comes in via deposition. The only format is it's not being done pre-trial, because it can't be done pre-trial, because all parties have precluded the ability for it to be done pre-trial by your actions. I mean, that's really as simple as it is. So whether it's video or it's reading I thought gives the pause aspect versus the clipping for a video, but
Yeah, I think the problem, now I'm also a reader. I like readers, I grew up using readers. But the problem you always have with readers is you have to educate them to certain pronunciations. They'll say the names of different things wrong. And so if there's a way to use the video and stop it, and everybody's happy with that technique, I'd rather do that.
We would agree with plaintiffs on that.
Counsel for HEG?
That's fine, Your Honor.
Okay, so that you're gonna have to ensure, right, from a technology standpoint, question any of these excerpts, right, that you have. You're gonna have to work among yourselves and figure out the way to get it done, because,
Yeah, Judge, I think, just off the top of my head, I think what we would do is we would prepare a video that has the objection stopped. We give the video to them so they are happy with where we stop it, because sometimes the objection comes after the answer, unfortunately, in some of these videos. So we have to make sure that's done, and then we can do it that way. If
but
that's
you
okay.
understand, it has to be page and line, it can't be blanks, right?
No, we will have a hard stop every time there's an objection.
Counsel, I'm not sure if you had the benefits, did you look at actually what was submitted to the court?
I looked at 2 or 3 of them, Your Honor, because I had to do the final edit on a couple of them.
You can go to Kessler, you can go to Fisher, you can go to several of them. There is blanks. There's not even a page and line designation. See the big huge blanks?
Yeah, Kessler, as I understand it, that is the generic objection, the first 2 blanks, that they're objecting to everything on grounds that prior complaint should come in. And then we get to the last 3, which are the actual page and line objections.
And where's the secret decoder ring that tells the court that?
I didn't prepare this, Your Honor, I'm just telling you what my understanding.
Okay, but
Yeah,
put new eyes on it,
right.
okay? Now you put your color code, I appreciate in the, attached to the letter dated the 22nd, that says it really is the 27th, which really is after hours on the 2nd,
Mhm.
which was in the back of the outbox. Almost impossible to see for anybody who's looked multiple times for it. The only thing I have is key to objections and designations. Do you want to try reading the key to objections and designations to see if you can put that side by side with what was actually submitted to the court? Because nowhere in here,
Is that your Kessler, Your Honor? 'Cause mine was,
now I'm contained in the envelope that the court got this afternoon, right? Is this little half page that says it's a key. Because you can appreciate as soon as we found it, okay? Despite everything else in the court's docket, tried to drop everything to figure out if there was any way to move forward with these. The only thing it says is designation, plaintiffs is in blue, real waters is in orange, ETT is pink. Then it has a strike through, designation withdrawn, and then it says objections, corresponding chart setting forth pages in line are subject to the objections. But there isn't the chart that's showing pages in line, there's blanks. So I thought, maybe it's just an oops on one, but then I kept looking at the other ones. They're on most of them. So counsel, you understand why the court's asking a question. It's not that I can't read, because I can read. It's just, when this tells me I have pages and lines, and there's no pages and lines, unless it's in invisible ink, you
I
can
think I
appreciate it,
understand, Your
huh?
Honor. You don't have what I have, is that what you're saying? You do have.
I don't know what you have. You have to realize, nobody can tell me what I even have.
Okay.
I can tell you from Lori Kessler. Take Lori Kessler.
Okay.
I look at the objection chart.
Right.
Go to the first box.
The-
But designation is blank.
Right, that's the generic designation.
And how would one know that's a generic designation?
Yes, Your Honor, that was
Or you
our
go to the next
mistake.
one, how would the court know? So am I ruling on, what am I ruling on, from what page in line to what page in line? Right? And one of them's real water and one of them's terribles. So are they objecting to the same section, a different section? What section are they objecting to?
They're objecting the entire deposition on the theory that prior complaints are admissible.
And if the deposition is, if the witness is allowed to testify at all, the page and lines are the specific page and line objections.
And where is that presented to the court? In what format for the court to have prepared for today?
Your Honor, I do apologize, it's not as clear as it should have been.
Where is it anywhere? If you're saying it's not as clear, where is it anywhere? I'm holding up the only two pages.
In retrospect, we should have put,
Okay, your statement says pages and line, right? Corresponding chart setting forth pages and line that are subject to objections. Roman little 2I, the identity of the party objecting, 3, a brief description of the reason for the objection. Okay,
Mhm.
so there's no pages and lines. So as soon as I got to that one, it's like, okay, there's no pages and lines, so does that mean that there's no objection? But yet there's objection on a basis for objection. What pages and line are we talking about?
If you look for the reason for the objection, the motion to eliminate is there, and that's their overall objection to any prior complaints for the motion to eliminate. So in the motion to eliminate, they objected to the entire deposition.
But the court already ruled on motions to eliminate. So you can't cite a motion to eliminate as an, if you can cite it that it's precluded, if you're saying the court already ruled and you cite the order, but you can't say your interpretation of a motion to eliminate is, I'm just saying, counsel, there's no way to know that that's a general objection to the whole
I don't disagree
testimony.
with you, Your Honor, I'm just saying that this is their objection, that's the way they objected to it, so.
But one says real water, one says terribles.
They both
So how would
say-
one know if terribles is the same as real waters as far as the whole body of the witness?
Because terribles, right there, it says terribles joins the objection.
Above, and generally, there's
Yeah.
this testimony, right, but what's this testimony?
The testimony about the prior complaint.
The whole witness testimony is about her prior complaint regarding real water, and they object to the whole witness. I understand.
But where does it say that, counsel? This is depot designations, pages and lines. That's what the court was supposed to be ruling on because of how it was not done correctly the first time. So then, the second option, and you all specifically promised this court on the 27th you would timely get it so the court could prepare. But you chose not to. You can't say that providing after hours yesterday with no heads up, no nothing to the court. Not even asking the court, Your Honor, we're running late. Is it okay if we drop it off late? I mean, despite the fact somebody stuck it in the outbox way in the back, but, okay, after 5 o'clock, when was the court supposed to go digging and fishing and finding this?
Your Honor, I should have alerted the court that it was coming when it was coming. Based on our discussions on the 27th, the
You
court
all
had.
promised timely to the court so the court could prepare, did you not?
Well,
Your statements were, Your Honor, we will get you, right? Mr. Parker's joke about we will get you the secret decoder ring, and then your statements thereafter, Your Honor, we'll get you timely, we'll meet again, we'll properly, timely designation so the court can make the rulings, right? And did you comply with your oral representations in court? Counsel, you know you didn't. Nobody did. Nobody bothered looking at it. You just dumped it on the judge and just figured, oh, she'll just deal with it. That's not what's gonna happen, because it can't happen, because in order for the court to make well-reasoned rulings, the court has to know what it's ruling on, it has to be clear, and there's no way to tell from what you all presented to the court to do that, okay? It is an exercise in futility that you all created to your own client's detriment. So the way to handle that is, you still can propose your testimony as if the witnesses were live. You raise your objections in front of the jury. You all get to, you wanna say 10 objections in front of the jury? As long as they're not speaking objections, feel free. As long as they're proper objections. If they're not proper objections, the court will have to take whatever action it is. But you're not gonna have this, right? And you're not gonna be raising motion to eliminate issues. Remember, what was these designations are the same things if you're saying it in front of the jury. You would not be saying in front of a jury, well, we think this is part of the argument on the motion to eliminate. No, you work that out before it even comes before the court, okay? And there's rulings on it, on the motions to eliminate. The motions to eliminate say what the motions to eliminate say. Things that were addressed, things needed to be deferred, all those were ruled on. So, whether you do it by video or whether you do it by reader, you all are going to decide how you're going to do that. The court is going to do what the court needs to do, which is, if an objection comes in, regardless of the method by which the witness is testifying, the court will address that objection. To the extent, and this is probably something Real Water and ETT might want to pay attention to, is to the extent you all are objecting to a witness overall, then there was motion to eliminate opportunities and motions to strike witnesses. And there were things that the court said specifically before anybody asked in a particular area that need to be brought to the court's attention outside the presence of the jury. If you all chose not to file your motions in a timely manner to exclude testimony or exclude witnesses overall, that ship has sailed. You all chose not to do it. There was deadlines, there was extension of deadlines, there were CMOs, and everyone had a chance to do it. Same thing with plaintiffs. If there's a witness or certain testimony that, or certain totality of a witness's testimony, you had chances, everyone had a chance to include or exclude. You had to include or exclude by topic area, you had to include or exclude by witnesses, and you all had that opportunity, and you, not exactly like you didn't file motions eliminate, right? We went through those for a number of days. People filed all the motions eliminate they wanted to, and the court heard all those motions eliminate. So, the court doesn't see that how there possibly is any prejudice to anybody. The only question really before the court is Bush. We need to get to Bush. So is Bush, you all want it completed, or you don't want it completed via the court doing page and line? Mr. Pepperman, you said there's two. Can you find me where the two is on the chart you gave the court? Because that sure is not two, unless, like I said, I don't know if what you've got is different than what I've got. What do you all have? Is there only two on Michael Bush that are left? Counsel, Mr. Pepperman?
It,
Two versus 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Oh, I thought, was about 18 is what this court counts. But one just says an R. Is R an objection these days that the court's not aware of?
we indicate relevance with an R.
Where? Where? On what? Where? What we presented to the court? Is there some secret, I'm going back to my secret decoder ring, is there somewhere it says R equals relevance? Because sometimes they say relevance. And you understand in your basis for objection, it includes things, also contains unnecessary objections and admonitions. What objection is that? That's supposed to have been cut out. So counsel, which two do you say are left versus the 18 listed on the chart?
On what I received from Mr. Bush,
Counsel, I'm looking at the chart. Does the chart,
138, line 21 through 147, line 11.
hold on a sec, 138? Mr. Bush. Okay. You understand page 2 goes back to lines 13, 14, etc. Some are crossed out, which the court was understanding that you were saying the court already ruled on those, or is those withdrawn? Or does this chart now include things I've already ruled on and things I haven't ruled on for Bush?
With Mr. Bush, that was lined out for everything you ruled on, and the last two.
Okay, counsel, you understand? Page 2 of your objection chart starts at page 13, line 16, to page 14, line 15. Is that not what you have? And it has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 objections listed on that page, with some of them having an R.
Oh, I understand, I see the confusion, I apologize, Your Honor.
It's
That
not
was for
confu-
Myles Hunwardsen, is accidentally included behind Michael Bush. Michael Bush's revised designations are only one page, so it's the last.
Okay, so that's not a reference to the case? Because I went looking for these depot sites, and I must tell you, Councilor with Real Water and AT&T, are you keeping up on this? What's your chart show?
Yes, Your Honor.
Do you have a 3-page chart?
I have the same chart, Your Honor.
And nobody noticed this and wanted to tell the court and say, guess what, Your Honor? We inadvertently sent you the wrong chart? Because it says Myles Hunwardsen, that's the name of this case. You can appreciate that the court would presume that these were still for this case. So, counsel, are you telling me only page 1 of the designations for Bush really are the designations for Bush in the objection section?
Yes, Your Honor. There's 2 page and line sections that are objected to. 138, 21 through 147,
Okay.
11.
Counsel, you understand when you're saying that? Go to page 175. of the depot. See 17601 through 17608 is underlined in red, which according to the sheet tells me all the objections are underlined in red, which is,
Yes, Your Honor, we withdraw that designation, so to resolve that objection.
you're doing it right now, or you did it before and didn't let the court know? Because then you can also go to 150 in orange. You got a similar issue. You understand why the court doesn't think anyone looked at these, that you all just headed them to the court and no one paid attention?
Your Honor, I can assure you that's not the case. I looked through these. There was a lot in a little bit of time, so
You all have had
there are
months.
certainly,
You've had months. Don't tell me there's a little bit of time. You've had months to get these depot designations, right? And many of these witnesses you already used in Gallagher.
it's just the revised objections. We received them on Friday, and went through to try to revise all of them and get it all straight. It was a lot of technical work in a little time over the holiday weekend, so I do apologize. There are mistakes. I certainly acknowledge we could have been clearer on some of these things. It wasn't our intent. It certainly wasn't our intent to make the court believe that we just dumped this on the court to let the court figure it out.
When did you give it to the court? How does that appear, counsel? When did you give it to the court? And nobody bothered to check it?
Yesterday evening.
Okay, and nobody bothered to check from any party? And you all have the same chart. You saw that there's 2 pages that says Myles, Hunwardsen. You would know that what it means, but no one bothered to tell the court that, did ya? We emailed you today even about trying to make this earlier because there was all this confusion. Actually, the time I emailed you, I didn't even know about this, so I was gonna ask you right off, and I hoped the email would trigger somebody actually getting me the jump drive, because we didn't. Or maybe it's when it showed up, we don't know, because it wasn't in the box yesterday late afternoon. Like I said, and all of a sudden it was there in the outbox at sometime after 10:30, between 10:30 and 11. We know that because that's when our meta case was supposed to be here. We were out looking for the attorneys. So, okay, that being said, what do you all want to do about Bush? We need to move this forward, okay? You all can address your objections in front of the jury.
Yes, Your Honor. I
Right,
would
does
agree
anyone
with
think that they're adversely impacted when you can address it in front of a jury? If so, tell me right now how it makes a difference.
Are you talking about the ones we've already done too, Your Honor?
Counsel, where I'm going for the global aspect, okay? I still haven't gotten a clear answer on Bush. I've gotten it back and forth on Bush, so I need to know which way you want to go on Bush. And then I'm going to address, if anybody's going to contend that somehow you have an entitlement to have these depot designations done in advance when you have not provided the court the tools to do so. I'd like to hear somebody's argument. If anyone's going to raise that, raise it now. Don't raise it to me post-trial, because realistically,
So the ones we've already done are fine, and we're talking about the remaining Bush ones, it has to be done for the jury. Is that what
with
you're
the clarity that Mr. Pepperman now saying that despite the objection chart having 3 pages, which looks like Bush, but really isn't Bush, because the last 2 pages really aren't Bush, so they're really Hunwardsen, but they were put under Bush, and that with regards to the reason why he said 2 is even though 176-1 through 8 specifically says it's not withdrawn, only 176-9 through 177-25 are withdrawn, that really plaintiffs meant to withdraw that even though that wasn't withdrawn, which is where I think Mr. Pepperman was getting to the 2 ones, which are 138-21 to 147-11, and 155 to 150-9. Mr. Pepperman, are those the 2 you're now referring to?
Yes, Your Honor.
Okay. So with regards to those 2, I understand, and I haven't even heard everyone's agreement that there's not other ones that aren't on this objection chart, so I'm gonna have to circle around on that. Counsel for Real Waters, any other objections other than those 2 that still have to be addressed in Bush, to your knowledge?
Not to our knowledge, Your Honor.
Counsel for ET&T Terrible, is there any more?
Not to, no, no.
Okay, so, with regards to those 2, because plaintiff's counsel, you told me you withdrew 176-1 through 8, correct? You withdrew the designation?
Correct, Your Honor.
So since they withdrew the designation, counsel for terrible, it appears that only you object. Well, I have to get that clarification. in the column that says, it says who objected, would it be correct to understand that Real Water did not object if it doesn't have your name in the objection?
In this case, yes or no?
In this case, oh, that's a scary thought.
This is actually Real Water's designation and plaintiff's objection to the designation.
I'm talking about page 176, lines 1 through 8. At
Oh.
least in that one,
I'm
that
sorry.
column says it was the designation of, the party objecting as Terribles. So that meant it was either Real Water's designation or it was plaintiff's designation. I was indicating, because if I looked at seeing plaintiff was drawing the 176.9 through 177.25, that meant it was plaintiff's designation, because then if I cross-referenced that with regards to the color code, which was the green color code, that meant it was a plaintiff's designation. Terrible objected, but since on the 27th, I was told that Real Water sometimes had a position, even though it didn't show them objecting or joining anywhere in the objection box, and since this version doesn't have both parties, more than one party listed under the objecting party, and instead only lists one party, I was double checking with Real Water to find out if they had an objection, because remember on the 27th, there were certain ones that if it had orange, whether it was orange on top, orange below, or not orange at all, that sometimes Real Water had a partial designation, so they had a position, because plaintiffs, you asserted the Terribles only objected to yours and didn't object to Real Water's when it was the same designation. So I'm trying to see if that issue still exists, because no one has told me whether it does or does not exist for today's purposes, which is why I asked Real Water whether or not on 176.01 to 176.08 they have any position, or because Terrible seems to see it's okay for plaintiff to withdraw a designation, but I wanted to make sure from Real Water if they had a position, because on this one, in light of what was said on the 27th and nobody telling me it's anything different for today, I just don't know, so I have to ask.
No objection to 176.01 to 176.08.
Being withdrawn? That was plaintiff wants to withdraw that designation.
Yeah, we have no objection to them withdrawing that designation.
Counts for Terribles. Do you have any objection to plaintiffs withdrawing that designation?
No, Your Honor.
Okay. So, now with regards to Bush. 138.21 to 147.11. Who, I then need to go to that designation, right? That designation, is that still, that is a Real Water designation, is that correct? Because I'm seeing it in orange.
Yes, Your Honor.
Okay, Real Water only, correct? Not a plaintiff designation for that section, is that correct?
Yes, Your Honor. That appears to be.
Okay, counsel for plaintiffs, is that correct?
Yes, Your Honor.
Okay, so then I go to the objection. The objection was raised by Terribles. Did you also designate that same section that Real Water did?
We did not have an objection, Your Honor.
Is it your designation as well?
No, it is not.
Okay. So the only parties I need to discuss this one with is plaintiffs and Real Water. Real Water was your designation. The objections are plaintiffs, foundation, hearsay, completeness, relevance, and cumulative. Walk through each and every one, counsel for plaintiff, and then I'll let Real Water respond. How is there a lack of foundation on that section?
So this section is asking questions about a Silver State Analytical Laboratories document. No one from Silver State Analytical Laboratories has testified in the case.
But doesn't he say in the very first answer that these documents were given to him, so why would that lack foundation? You raised an objection on foundation, how would that lack foundation?
Well, we don't know where the document, how the document was created, what was the purpose of the document.
How does that go to foundation, counsel?
There's no foundation for the document, Your Honor.
Is the document being asked to be entered, or is it only his testimony with regards to the document?
I'm not sure if Real Water is proposing to admit this document with respect to Mr. Bush, but to the extent that they are, we object to that.
When you all did your meet and confer, did you discuss whether or not Real Water was intending to introduce the document in this section when you made your objections? And if so, what was the response?
We didn't discuss that specific issue. But it's really a multifactorial issue with showing him a document that he hadn't seen before, that he recalled, ask him if he recalls this. He says, oh, I remember something about that. So we object that he has the foundation to testify about the particular document or the testing. And even if he did,
But he says he doesn't. Because there's a question, do you know what quarterly NSF is in terms of project for the testing? His response is no, not set up with this, no, I was just told, take this document when they come in. No, I remember, okay, I remember, I'm sorry, this was a little while ago, I'm trying to remember, I remember the person would come in, he'd say, I mean, I understand your hearsay objection, but I'm going to ask you whether it's a managing, all right, whether hearsay, and then I'm going to ask a response on hearsay, but for foundation and speculation, right, you made these objections, so I'm trying to have an understanding on what was your good faith basis for making these objections.
the basis is this witness doesn't have the foundation to talk about the testing or the testing documents because he recalls something general about it. He had testified that do you know what the quarterly NSF is in terms of project for testing? No, I don't know. He just would take documents as they come in, and that testimony, we believe, is insufficient to establish a foundation for any competent testimony on this testing or document. It's hearsay because it's based on what other people told him without any idea if there's a hearsay exception, and it's irrelevant because he's admitting he doesn't know anything about it.
What's your, the objection is completeness. What evidentiary objection is completeness, please?
I think the intent for the completeness objection is,
What
and
was your
maybe that's,
objection, so what was the objection basis for completeness, please?
that what they're trying to introduce this idea that there was testing done at Real Water through this witness who doesn't know anything about it.
But how is that an evidentiary objection, counsel? I'm trying to get to, right, these have to be proper trial evidentiary objections. Are you telling me completeness is a proper trial evidentiary objection? Or it's something preserved from something else, and so therefore it would get treated as a trial objection?
I think it probably more goes to relevance in that it's not a full picture, so it's misleading, confusing, and unduly prejudicial.
But you don't have that. You have foundation, hearsay, completeness, you do have relevance, but you don't have,
Yes, Your Honor, I
and then
shouldn't
you
have
have
been.
cumulative. How is it cumulative? And what does the distinction of it mean in paren? Is that a real objection, or is that what's a paren objection mean on these charts?
We can withdraw the cumulative reference. I think that might have been related to a prior testimony, but there's no need to get into that. The testimony lacks foundation, relies on hearsay, and is irrelevant or unduly prejudicial for the reasons stated.
You don't have prejudicial, right? That box doesn't say those words, does it?
Your Honor,
We're not
my
adding this,
intent
right,
was-
you all get 2 rounds of purported meet and confers. Please don't tell me that you're gonna try and raise a new objection now, today. You know what, counsel, we're not doing this anymore. Do it in front of the jury. Raise all your silly objections that aren't real objections in front of the jury. Waste the jury's time. Court's gonna have to address these at the time of the jury, because we're not gonna continue on this. It's made clear that you can. So, the answer to your question, Mr. Kemp, is no, Bush is going the same way as everybody else. Because we're not gonna split it up part by part. If I can't even get through one segment with people even telling me that there's any basis for what's put in those after 2 rounds of meet and confers, you can appreciate, say it in front of the jury and let the
I
court.
understand the court's frustration now.
Court's not frustrated, the court is ensuring that everyone has a full opportunity to be heard, and you'll be heard in front of a jury. You all have included the opportunity for the court to rule on this pre-trial. I was going to try and do this, because it said it was only a couple with Bush, after you all decided to take away the 17 Hunwardsen that were added to this as being Bushes. And so since you can't even get through the very first one with even saying that there's a good faith on all of those that are raised, you can appreciate, say it in front of the jury. So, Bush is gonna be in front of the jury as well. Whether you all do it by video and stop it each time, or whether you do it in reading, is gonna be how you all jointly agree on it. But you're gonna need to make sure, well, let's see if we have an agreement here today. Do you all want them read, or are you gonna do it video, and you have the means and tools, and you're gonna spend the time to do it video? Remember, you have to raise your objections in front of the jury. You're not gonna say, Your Honor, look at our chart from X, you're gonna have to raise it. And you can appreciate why, right? Because this ever-moving chart, which doesn't even have page designations in many cases, is not appropriate. So you're gonna have to raise it in front of the jury. Are you gonna do it by video, or are you gonna do it reading? Because we're not gonna have a jumble where people say, we object, and therefore you want me to address it, right, during jury selection. That's not fair to our members of the jury. So let's decide today which way you're doing it.
Judge, I think video would be the better way to do it.
Mr. Kemp, could you just turn your mic back towards you?
I think video would be the better way to do it.
Joel, do you on behalf of Real Water, we agree?
Terrible Herbst agrees, Your Honor, Valerie Rojas.
Okay, you gotta make it happen. Take the pause and then raise your objections, right? Evidentiary objections, please. And question by question, you're not doing whole swaths of arguments, right?
Yeah,
Whole
Judge.
swaths of pages, question and by question, the same way as if the person was testifying live. That's the way they're supposed to be done.
And it's supposed to be, they're limited to the objections made at the time of the deposition, Your Honor. They're not supposed to be able to add new objections at the time of trial. So the objections are set forth in the video.
I am hearing what you're saying, but do you think you all have complied with that with regards to each and every one of the depositions? That's a mutual agreement by the parties. Fine, the challenge here is, as you know, is if the person was coming in live and they had their deposition, then you're not limited to the objections raised at the time of deposition. Because you can, now you have the ability for impeachment, and the court's not gonna go to the carve-out when you can use a deposition for any purposes, you know, when it's a party opponent. I'm talking a general sense, right? The
Right.
general sense is, if a witness is on the stand, they may not say it exactly the same they said it in a deposition, and there may be objections raised at the time of trial. So if you all want to stick with the concept that since these are all depositions and you're only preserved whatever objections were made at the time of deposition, then I will hear said stipulation. If I have a difference of opinion, I'm gonna have to hear said difference of opinion, because once again, this court does not know. Because remember, some of these depositions may have been taken and designated for another case, but all parties have an opportunity to participate under the CMO. I did not see anything in the CMO that specifically put people on notice that a deposition could be utilized at trial, and they'd be limited to any designation stated on the deposition. So let me see if I have an issue, if you're all in agreement. If you're all in agreement, it's a non-issue. If you have different positions, then I'm gonna have to hear that different position in order to answer your question, Mr. Kemp, okay?
Joel, do on behalf of Real Water, we believe that the parties should still make their objections for the record, as the depositions are played via video. We don't believe those are waived.
Okay, so counsel, just so I'm clear, okay. So are you saying that you have preserved the depo objections if they're not raised at trial, and in addition you make trial objections? Or are you saying trial objections, and so therefore whatever were depo objections are already gone because we're just treating this like a witness at trial? Or how, can you clarify a little bit what you mean?
Yes, Your Honor. This one's a pretty good example. Obviously, Mr. Bush was testifying as to a subject that was not objected to during his deposition. Plaintiffs have objected to it now for reasons that they believe are valid, and we believe the court should rule on something like that. If we had the same objection, we would make it. So we don't believe that they have waived, and we don't believe that we have waived.
Okay, Counselor ETT, your position.
I would agree, Your Honor, with Real Water, and there have been a number of changes, obviously, in issues that are no longer issues in this trial that may have been issues for purposes of the deposition in other cases.
Counselor Plaintiff, after hearing the positions of Real Water and Terribles and then pointing to one where
Well,
they
Judge,
say that you raised objections for the first time,
I live by the rule that we propose, Your Honor. I mean, the reason that objections are required to be made at the time of the deposition is to give the questioning party an opportunity to cure the objection. So for example, for them to come in now and make a brand new objection, say on foundation, that I could have cured, I mean, that would be inappropriate.
but you all just, you understand, do you agree that the excerpt that just was referenced, the 138:21 to 147:11, is where plaintiffs added new objections?
I've got to live by the rule too, Your Honor. So if I didn't make the objection there, that comes in.
Okay, well, here's what the court's gonna find is the more fair way to do it. The more fair way to do it is you all had your second meeting confer, so you're stuck with what is on these objection charts. Because you all considered that, you all told this court, as officers of the court, that you have raised all the objections that you think were appropriate and timely for purposes of these designations. Your designations are not gonna go outside of what's already been presented to this court, meaning people aren't going to add additional designations, because that would not be appropriate, because nobody's had an opportunity to do meet and confers, and that time has already passed, right? So realistically, in fairness, since certain parties may not, you have parties coming in and out of various cases. You have certain parties may not have thought they were going to be in cases. You have parties that may have been looking at a deposition and testimony different. For example, at the time of certain individuals' depositions, Real Water might bring to the attention of the court, they didn't have a stipulation as to liability and causation, so they might have treated what objections they would raise at time of deposition different than if it was trial testimony. And since that's been raised to the court in previous arguments, is why I'm referencing it now, even though it was not specifically stated today. So if I look at that global fairness concept, it is appropriate that people, if they raised an objection and it's in these objection charts, then it's fair game to raise in front of the jury at the time of trial with regards to these individuals, because they would do it if they were able to do live. My ruling has a carve-out. The carve-out is if there is another rule, i.e. NRCP, which allows depositions of party opponents' right to be used for any purpose. My ruling is not covering those that may have some additional opportunities or some additional challenges. Does everybody understand what I'm saying
I
by that?
understand, and we're fine with limited to listen to both now.
Counsel for Real Water. I'm treating this right now as an inclination. I'm giving everyone an opportunity to be heard if they wish to be heard. Real Water, do you wish to be heard?
Your Honor, Joul is for Real Water. There were a number of motion and limited rulings where the court wanted to see the testimony of a witness. So we would understand the court's ruling, and that when that testimony is proffered, make our objection and argue the issue outside the presence if necessary.
So what you're saying is, which would be consistent with what I'm saying. If I made a prior ruling, that's, so
Yes, Your Honor.
to be consistent with the prior ruling with the court, or there may be some carve-outs, there may be the other carve-out with regards to deposition and depositions being utilized, this is the easiest one. Depositions, being utilized for any purposes for party opponents, and we're gonna have to get a clarity on quote who the party opponents are and who those are when we have three parties and who's going to be viewed managing speaking agent, which we'll get to in a moment, but okay. So you're okay with being bound by the objections in these, other than if it's a motion limiting objection, if the court says deferring because it wants to hear actual testimony?
Yes, Your Honor.
And other than the NRCP? Okay, let's flush that out. I'm just trying to hear what you're saying, and then, counsel, I need to hear everyone's position, and we're gonna flush it out. Okay. Is that,
That is our understanding, Your Honor.
okay, counsel for ETT, what's yours?
That would, my understanding would be the same, Your Honor.
Okay. So,
So Judge, how are we to deal with new objections now?
no, it's, okay.
He just said they want to make new objections in addition to what's in the book.
That's why I'm about to go to a clarification point, because in these objections, in these charts, there's a reference to motion limiting. So I need to get a clarification from Mr. Odou as his statement that and once again, let's realize when I got this in the breadth of what I've got, it's not even clear really what people's positions are. That's why I have to ask these clarifying questions. From Real Water's position is in these, and everyone understands what I'm calling the objection charts, right? Those are the charts that were attached to these depot designations, okay?
What I've just called the book, right.
okay? They're a chart, everyone understands the charts, right? Okay, so are the motion and liminae, because there's a whole bunch of them
Yes.
that have a reference to motion liminae, does that subsume, or are you saying that there's designations that have not been put in the charts as referencing a motion liminae that you think has been deferred that still would need to be addressed?
We have objected continuously. We objected at the meet and confer. We objected in the pretrial disclosures. We objected in the chart.
Can
So
you give
there
me
are
the-
not new objections.
Okay, and that's where I was trying to go, okay, when I use the term chart, okay, what I was including in the chart is because there is a reference to motion liminae, right, but there's no indication on which aspect of the motion liminae, okay? And we can look at, let's go back to, Lois was one example, right?
But Kessler.
Lois Kessler,
Right.
okay? Lois Kessler, for example. In the designation that has no designation, lines and pages, right, the first two block boxes, there's references, at least in the first box, to Real Water's motion liminae number 5, 9, 10, and plaintiff's motion liminae number 29.
That's right.
So, for your I'm calling it a carve-out, that's my words. For the carve-out component, since those were asserted in the objection charts, the court was including those, is that you still get to raise those objections because they were raised in the motion liminae, and you're asserting the motion liminae. Are you contending that there are motion and liminae assertions that are not otherwise contained in these objection charts?
Your Honor, we made it very clear as to what testimony we've objected to. My concern is, were all of those captured because we did it at the meet and confer over and over and over again? And I don't want to play the gotcha game where somebody has omitted something and we have raised it multiple times.
Okay, where would be a source for the court to look at to get an example of what you're talking about, something that you've raised multiple times?
The one I think of off the top of my head is Tom Pham.
Okay.
That testimony was excluded, it's still being offered. We objected at the meet and confer, we objected in motion and limine, we objected in pretrial disclosures. It was excluded by this court, it's still being offered. So maybe that testimony has finally been stricken, but I keep seeing the testimony about his neighbors specifically that the court's already said
Okay.
doesn't come in.
And it's interesting, counsel, we're all gonna look at the chart for Tom Pham, because interestingly enough, we can appreciate why part of the court's comments, because when I looked at the Tom Pham, remembering Tom Pham, right, because he came up lots of times, right, with the neighbors in the ambulance and the 2 different days and seeing the alleged bottles and, right? The only person who's objected to Tom Pham, according to this chart, Real Water, you're not anywhere on here.
I separately emailed Mr. Pepperman to make sure that it's on there. Let me look at their,
As we withdrew the,
and if it's not there, that's great.
There's no objection from Real Water on the Tom Pham because they only objected to the neighbor's testimony. The court ruled on it. We agreed that we withdrew it. It's not going to be played, so there's no objection from Real Water on the remainder of Tom Pham's testimony. And
I'm just trying to get some,
Judge, we took the neighbors out. We bypassed.
I'm hearing what you're saying, but you heard the court's question was, what's an example of something, right, that's still an issue?
I think Kessler's a better example, Your Honor, and that's where we start. Kessler,
Okay, so let's go back. Okay,
Yes.
so let me make sure with Real Water. Real Water, have you now had a chance to look at the designations that are set forth?
We will double check Tom Pham when we have a moment. I want to go to Kessler, I gotta pull up a different chart. That's fine.
Okay, well,
so Your Honor, on Kessler, this is my recollection of what happened. We argued the prior complaint issue. We pointed out how prior complaints were relevant to the issue of punitive damages, which remains the case. If you recall, I put up the 8 cases, we went through even Judge Jones's case. And the ruling of the court was the prior complaints are admissible, but the court allowed them to make specific objections, all right? That's what the ruling was. So
Hold on
what
a
they,
second, I'm looking, let's go straight to the order
okay,
on the motion to eliminate. Can someone give me a document number? Let's,
The orders have not been.
really? I think that might be on my checklist for the calendar call. Everyone's contending. That's why I asked the question, councils. I have no orders. People are contending things, right? Do the math, right? When were the orders due?
Your Honor, my recollection and my understanding from the discussion on this matter was that the court allowed us to provide the orders more than 14 days after the hearings in light of the holidays.
Which is why I'm asking the open-ended question. When is your perception of when the orders are due?
The orders are in the process where I know we're serving some on many of them today. We're trying to get them all done as soon as possible, but before the trial date was my understanding.
Go back and look at the transcript directly to see. I would be surprised. And how are you relying on oral pronouncements from the bench on your Division of Family Services in West versus Clark County to address the issue raised by Mr. Odou and why he's reserving his issue because there's no written memorialization of orders?
Your Honor, we have discussed this. We've exchanged and agreed upon on a list of the court's rulings.
We're trying to go back and double check. Your motions eliminate on the 14th. And 15th, okay. Counsel, you said you discussed, go ahead, please.
Yes, we have the transcripts of the court's rulings on every motion. For the joint pretrial memorandum, we included an agreed upon list of the court's basic rulings on each of the pretrial motions. We're in the process of preparing the orders right now. We aim to get them completed as soon as possible. Our view is, Your Honor's rulings are very clear and comprehensive. We're going through the transcript and
Well, thank you for the compliment, but you understand you're disagreeing about the scope of my orders today for purposes of depot designations, which is why I have to ask the question. The reason why I interrupted you, right, is, thank you for the compliment. However, if you all were on the same page of exactly what this court ruled, then why is there a difference of opinion on whether or not a motion eliminated precludes certain testimony or not?
Well, Your Honor, I think deferred part of the ruling on this one where I think Mr. Kemp was correct. Your Honor said that prior complaints are admissible for purposes of notice and that you deferred ruling on any particular testimony to determine if there's any hearsay issues or lay witness issues offering expert testimony. So I don't know that we necessarily disagree that that's the ruling. We may disagree on whether the testimony, some of the testimony itself is admissible, but I don't know that that is based on a disagreement of Your Honor's ruling.
Oh. You might want to refer to the 12/20 hearing transcript where the court reminded you of EDCR 7.21. But that being said, okay. In light of that, I have to go with what Mr. Odou's statement is, right? I have to do the carve-outs. Because realistically, I don't see it as a new objection, because to the extent it's covered by a motion in limine, and it's already set forth, sure, that would be today, right? Okay. Look at page 1, I'll read the transcript from 12:20. I figure you each have tech people that are quickly going to find that for you, so I'll go somewhere else. So let's go somewhere else, but I'm trying to make it a quick, easy page reference, because that helps for each side. Or sides, not singular, sides, okay. Mr. Kemp, to address the issue that you're raising, let me be clear on the issue you're raising. What I'm hearing you say is there's not a new objection being brought up for the first time at trial that has not been previously been memorialized in your meet and confers is now in the charts. And if somebody thinks that they're raising a new objection, that be done outside the presence of the jury for the court to address whether it's new or whether it has been previously preserved. Does that address your concern?
I think so, Your Honor. I
Okay.
think, and especially if we have, I mean, we sat down with the defendants, we have the tentative rulings outlined as a party's understanding. True, this isn't final work, but I think we've got something to work from.
Okay, once again, remember, I don't know what you all have. See this
This is
beautiful
part
crystal
of
ball
it.
that my extern gave me? It's beautiful, it's crystal, it's beautiful, but it does not help me read people's minds or get into the future. So
Yes, this is.
I presume as sophisticated litigators, you all have a lot of material that I don't have the benefit of.
Yeah, it's the transcript.
Judge, it's Exhibit 2 to the joint pretrial. It has our tentative list of the court rulings of the
Okay,
motions.
that's what you're, okay,
That's
like I
one
said.
version. Okay, and then I went to the ones that Mr. Odou references in the objection, starting with 5. The court denied it with some language saying that he could bring up specific
Okay.
objections.
Counsel, just to be clear, you and I might have something different. I have, under your exhibit 2, thank you for the nice binder, I have a chart, yes, but I
Right.
don't have, if you have excerpts from the actual transcript, that was not
No.
provided in my exhibit 2. Mine are just
No,
titlings.
I have our summary of the court's ruling in.
Okay, we'll use term summary, okay, you're just talking about a document number and like a 1 or 2 liner in ruling.
Correct.
Okay.
Correct. Okay.
Just making sure I've got, like I said, I don't know what you have, I gotta make sure I've got the same thing. So
Yeah,
counsels
so-
for ETT and real water, you have the same document,
Yeah.
correct? The exhibit?
Yes.
Okay,
So the process here is to try to expedite this process for deposition rulings. We prepared this chart and we want to make sure both sides agreed which way the court was heading on these before we had final orders. And that's the recitation of what our understanding of the court's
Okay.
ruling is.
so now let's go to five, right?
Okay, real water.
5, 9. Right, counsel for real water, is your 5 and 9, right?
That's right.
Okay, let me get to yours, 5 and 9.
That's 672, Your Honor.
I appreciate it, thank you, okay. Okay. So probably your better one is number 9, right? Document 617, which is on the, under real waters, motion eliminated to preclude the customer complaints.
Yes, Your Honor.
Okay. So, if I'm understanding, Mr. Odou, which was joined by, Council for Real Water, which was joined by ETT Terrible Herbst, that their position is, for example, motion eliminating number 9 is referenced in, I'm calling the objection charts for the depot designations. So they have preserved the objection in 2 categories. To the extent that this one covers a specific motion eliminate to preclude in entirety, that they have preserved that concept, but also 2 specific designations if certain portions come in, and that he was stating he didn't want to waive that. Is that
Yes.
correct?
Okay, and Your Honor.
Okay, so, now, I just make sure I understood his, now
Right.
let's go to what your concern on that is, go ahead,
My
please.
concern is that as a practical matter, if I'm gonna stop every time he has an objection, and I don't know where to stop, because he's objecting to everything, what do we do?
Okay,
That's
So-
so at a minimum, he should, and he should have done it already, he should say what part he thinks is objectionable under this generic objection. Instead of making a specific page and line objection, he's made a generic objection to the whole thing. And so now he's saying, okay, when you're playing the whole thing, I can pick and choose anything I want. How will you do that, Your Honor, without stopping and starting every single question?
well, you're asking me to do it here today, without
No, I
any
wasn't asking you-
guideposts.
I was asking you to rule on the 3 objections, and we think this problem's cleared up by the order when they're finally signed. But in
But
any
there's
event-
not 3 objections, counsel, because remember, Mr. Pepperman said there was the global objection to the entirety, which is the 2 empty boxes which didn't have the page and line designations. You all called it the generic one, and then you had the specifics if it wasn't the generics. So I'm just circling back, I'm trying to find a way to get you all moved forward so that you got some clarity.
Your Honor, if I can add on this,
Which means it opens it up to other side if you want a second horse, because, or second rider on that horse, because, is anyone objecting? I mean, it's been Mr. Kemp and Mr. Pepperman back and forth, I haven't heard anybody object, so.
Yeah,
Mr.
that's fine, Your Honor.
No
So-
objection, no.
Okay, so if you want the second person to talk to, you did it as well, fair is fair. Okay, go ahead, Mr. Pepperman.
Your Honor, based on the meet and confer and the discussions with respect to Ms. Kessler, and then a couple other ones, Ms. Doran and Mr. Fisher, real water.
Anyone walking out of the court when you're observing, you made an appearance.
Oh, you're talking about Mr. Kaufman walking in.
I'm sorry, Your Honor. I didn't-
Audio, ADKT 613, please feel free to read.
I'm sorry, Your Honor, I didn't hear you, I apologize.
Sorry. Mr. Kaufman appears to have gotten up and left. He made an appearance for this case, not just a general observing.
I will,
ADKT 613, right, the rules on, that's his view on following the Supreme Court's rules.
yes, Your Honor, I will caution Mr. Kaufman right now.
I'm more than glad to give breaks, as you all know, you all ask all sorts of times and all different things, but it's the same with
Yes,
your
Your
audio
Honor.
visually as you are, and I appreciate you probably didn't see it, it's just, right in front of me, watched him stand up, turn his back and walk out. At least I'll,
Yes,
maybe
Your
this
Honor.
isn't important enough,
I suspect it looked like a restroom break, but I'm speculating.
but you can appreciate anybody's asked for any break, right, regardless if they're remote or in person.
Yes,
Court's
Your
granted it, multiple ones, whenever you all want, for anything.
Yes, Your Honor, I will,
ADKT 613, that's Supreme Court rules.
if we could take a break, I will meet and confer with my colleague and explain to him again.
That his pro hoc vice application is to follow the Nevada rules, which include Supreme Court rules specifically?
Yes,
Please
Your
do.
Honor.
He's
May we-
back.
May we take a recess?
Oh, he's back.
He's back, Your Honor.
Yes, he, why don't we take a recess so we don't have this issue again, okay? People are making appearances, they need to follow the rules. If people are observing, they're welcome to observe, it's a public courtroom. So if it's just somebody asking me to do something different, some motion to seal. And as you know, this is very public because, remember, I have a media request, and so which I'll have to address. I have a second media request for the trial, but we're gonna get to that when we eventually get to the calendar call. At some time this afternoon, we hope. So this is a wonderful time for the break. See you back at 2:35. Thank you so very much. And maybe you all can speak among yourselves for a quick second to get the clarity of what makes sense for folks, okay? Thank you so much.
Thank you, Your Honor.
Same case, same parties, same counsel for plaintiff. Go ahead, you wish to be heard.
Your Honor, Mr. Odou is taking the position that he can raise any objection at any time if he can relate it to a motion to eliminate. I'm not gonna resolve that with him today, so I don't see any reason to go through the rest of the page lines, because it's really kind of meaningless, since he can insert any objection anytime he wants. So I think we should just move on to whatever the next issue is.
Court's not taking it. Mr. Odou, do you wish to be heard?
That's not our position. We did specific objections to Lois Kessler, page lines. They're highlighted in the transcript. We also did specific objections in the motion in limine, so, and in pretrial disclosure. So we've been very judicious in our objections and very targeted.
ETT, are you jumping into this one?
No, Your Honor.
Okay. Well, of course I can take a position, whether people are taking a position, whatever. You all have the documents, you're gonna show me what you're gonna need to show me. I was just trying to find an efficient and effective manner to try and allow you to get as much done pre-trial for the party's best interest as could be, but since it's not allowing the court to do so, we are going to move on. So what we're going to do with regards to Bush is, seems to me that I have to do the same thing with Bush that I did with everybody else, which means we all are gonna have to do it question and answer, objection by objection. I can appreciate that as well-respected, sophisticated counsel, you are not going to go in front of the jury on each and every question and raise objections that have no bases, because you all know the impact of things when people try and do such, and I'm sure no one is going to do so and have the court. So instead the court will have to address the court's not taking a position, because realistically, it sounds like you can't even really necessarily agree on what actually the underlying issue is. I mean, so the way to solve this is, please get me the orders on the motions in limine. As the court noted on 108, I reminded you all of EDCR 7.21, and then I reminded you also that I appreciated it was the holidays, and I appreciate you all were working on a variety of different things. And then I referenced West versus Clark County and Division of Family Services, and said, we don't get things that we need to get doing, because, said you might want to, figure out your time, but remember when your trial's starting and when you need to get these done, I appreciate transcripts and things, so I'm sure those are going to come in a timely manner. Do not try and provide them after hours, right before trial. If you do the math at the most generous aspect, right, 14 days from the 20th is today. So that means they were all due today. There's no request otherwise, so if they're not here by the end of today, you are all in non-compliance. Folks,
Judge, could I request that we have till at least Friday?
is that a joint request from everyone?
We would also join in that request, Your Honor.
We would join in that request, Your Honor.
Well, you can appreciate the court's in a multi-day evidentiary hearing. That's what those two boxes of binders are, plus a lot more to come. And that's the tech check that we were doing today, so the court, not telling you to have a chance to look at them Friday or Monday because it's a multi-day evidentiary hearing, but they're before end of business on Friday, that's fine. I realize you all are trying to do a lot of different things, but the point is, if you're raising the orders for the court not to be able to make rulings on things, then the court's gonna have the orders in order to make rulings on things, right? And notice of entry of order. So let's see what we can actually move you forward on. So deposition, designations, the parties are gonna work among themselves. I understand that there's a preference to do it audio-visually versus reading. You need to do it and ensure that you give the opportunity, so if an objection is going to be raised, the objection can be raised. What the court is going to ask the parties is, with regards to what I'm calling your objection charts. I'm going to need those, but I'm also going to need, to the extent that there's like blanks, whoever's the objecting party's got to fill in what that is, because I'm going to utilize those as a reference if someone's going to raise an issue about a timely objection or not. I'm not making any advance rulings. I don't, I can't, I won't, and I shall not. However, that is a good guide for the court, that at least people were on notice of certain things. But if there's got a blank on it, then whoever leaves that blank, it's at your own risk. Everybody understands that? Because then the court won't have any basis of what lines you're potentially objecting to. And no, the court's not going to take it in a global sense that that means everything. If you don't do page and line, then that's at your own risk, that you may not have had an objection. I said that clearly to everyone, so you can fix it. If you don't wish to fix it, then the court will have to address what it has and address it at the time. You are now making your trial a lot longer, but unfortunately, that's where it has to be, it appears. So, now let's go to the next.
Judge, we have a due date on those objections. You said they have to, instead of making blanket objections, they have to make specific. Do we have a due date?
Well, no, okay, where I was going, counsel, is I gave a couple examples, like Lois was one of the examples, Kessler, right? There was a box where it had no page and line.
Right.
This court has to have an understanding of what is the page and line if there's objection. I mean, presumably if a person's only objecting to one question and answer in a whole depot, then this court has to have some idea. If somebody's saying that they've preserved it to the whole depot, then I have to have that idea, right? So, to answer your direct question, yes, I'm gonna give you a date. I really was gonna ask you what's doable, folks, because you've got a lot of different things on the fire. I appreciate that, but we're also starting trial, so.
Well, Judge, it's actually a bigger problem for them than me, because I can try my case without depositions on video if I had to. I don't want to, but I could. So there are 9 videos that I would ask that they at least get me something to, in the meeting in the near future, so we can at least consider playing them.
Counsel, you said 9, there's 19
No,
in that
there's
listing.
9 that I intend to play in my case in chief.
Oh, okay.
I'm not addressing their stuff.
Okay.
They have their own stuff. So I would ask that.
I was hoping you were saying the 19 were going down to 9, because that would be
No,
nice.
no, I'm not gonna play, when they.
It doesn't matter, okay, you've got 9 for your case in chief that you care
Yeah,
about. Go ahead.
I'd ask that they give me, their specific objections to the 9, which, you know, at least by Monday or Tuesday next week.
All around, okay. Tuesday the 9th seems fair for everyone, for all objections, for all sides, plaintiffs, defendants, right? Because that's 1 week before the trial starts.
That's fine with us, Shirley.
Now, I'm in no way saying that you get to expand your objections. What the court really is saying, if we're being 100% clear here, is to the extent you have a blank in any of those objection boxes, and you wish to fill in said blank, because you're really gonna make an objection as to something, then you're having that opportunity to do so. That doesn't mean that you get to expand it from pages that are not within, or the deposition that's not an issue, okay? Only for those blanks, so that it's clear. Because what I'm trying to minimize is somebody saying, guess what, this objection is being raised for the first time at trial, and it never came up before. So I at least will have a chart, so I'll ask you all, show me in the chart where this is, right? There's brand new pages and things, and you can appreciate the court's gonna have to evaluate that. If it's on the chart, I'm gonna evaluate that. That in no way is minimizing other objections that people may have timely done at the time of their deposition, or other objections that may come up at different time periods under the NRCP. I'm not in any way constricting, minimizing, narrowing that. I'm just going to find this as a resource to utilize for a notice concept, because realistically, I may do it even as a court's exhibit, but we'll see. I'm not sure if I'm going there yet, because I don't know what I'm gonna get. Mr. Pepperman, you're standing. Mr. Kemp wanted me to move forward. Do you want me to stay here? Go ahead.
I would just request some guidance on that issue, because the blanks, which I understand created confusion, was indicated that the party had an objection to that witness testifying in general.
Then they could type in objection to witness testifying in its entirety, right?
Okay, so that's the best way to communicate that to the court. If it's an objection to the witness testifying at all, that's the objection. And if the witness is allowed to testify, here are the page and lines that we object to. Because we have the page and lines. So for Ms. Kessler, for example, Real Water objects to her being called as a witness at all. If she's allowed to be called as a witness, then they have no objections to the designated testimony.
Not exactly.
Terrible Herbst said we
Wait,
object.
you heard that not exactly right. You understand, while I am seeing all the facial expressions, I am really appreciating good lawyering and making sure that everybody keeps their caveats, et cetera, right, when they choose to still be here during the hearing, you can appreciate this ever-changing, I think I've used the word landscape, I think I've said I need a secret decoder ring, I think I've raised it in a variety of different ways. You can appreciate this court, you all don't have clarity on where it is, okay? So your top secret, orange this, not orange that, underlined, not underlined, it's on something, it needs to have some clarity. The best clarity this court's gonna get is if somebody wants to fill in those boxes, they can fill in the boxes that are blank. Everyone has the same opportunity by next Tuesday at 3 p.m. Pacific time to fill in said boxes. Not to add anything else anywhere else, only if the box is completely empty, because that gives an opportunity, everyone equally. And then the court will evaluate what is or is not there. It's not giving anybody any extra. It's not taking away anything. It's just giving the same equal, because to the extent that there was any understanding by any party that one party possibly was taking care of things and they may have meant something different by their block box and keeping it blank, I'm giving everyone a chance to fill in their own boxes so nobody can say we were relying on somebody else. If people don't choose to fill in their box, then I have that. If somebody chooses to fill in their box and they've tried to go over something, then I'm sure somebody else is gonna raise it to the court when that comes up. That's really the best this court can do, because you all can't give me a clear understanding of what the parties really want.
Fair enough, Your Honor, thank you.
Thank you.